Welcome, ladies and gentlemen. Why patents and how? Patents in mid-sized companies. This will be the topic of our today's talk with my colleague Joachim Marder, patent attorney at Bardelli Parkenberg. Why patents? They are the only legal monopoly. But how to enforce patents? And do they need to be enforced? Really? In many cases they do. But how to obtain patents in time, quickly enough to protect your technology before it is outdated?
Well, patents provide a monopoly for certain technical solutions, in theory, until the patent expires after 20 years after filing date. But in practice, very often we see it that the technical solution becomes outdated before the 20 years are up. What patents actually cannot do is offer you a comfortable, laid-back position, because the competitors do not always respect your patents. What they do is they give you a certain distance, a distance between the innovator and the follower.
Yeah, and they create recognition. Recognition towards the outside, obviously, in the competition. These are the guys who make inventions, who find the non-obvious solution. And also to the inside. We're a tech company, we're innovators.
Another thing that we often experience is, as you know, patents are also very useful as a counter-threat. So when your competitors have patents, actually you need them as well. Maybe not even to protect your own technology, but to have some material that when you get sued, that you have a better position to counter-sue, to put yourself in a better position in settlement proceedings.
That requires oftentimes the enforcement of patents, right?
Absolutely. Some competitors, they respect your patents as long as they know about them, which is very often not the case. There are like more than 60,000 patents granted each year in Germany, and it is very hard for any company to be up to date about the filing practice of the competitors. Other companies may know about the patent, but they choose to ignore them as long as they're not addressed by the patentee. And yet others
just fight it out.
Yeah.
They fight it out with all inventive theories of why they don't infringe or why they think the patent's invalid, and their enforcement is definitely needed. Now, I usually say to clients when they are shocked about a patent suit being necessary or even hitting them, litigating patents is normal, that's what they are for. And litigation should be considered to be a normal process. There are more than 1,000 cases filed per year in Germany. And they are heard and decided and have, of course, their consequence in competition.
And litigations, we see it all the time, already have an effect on the defendant even before the cases are decided. At the beginning of an litigation lawsuit, the defendants typically, they try to find alternative solutions to avoid the patent. They have to think about, well, a solution for the worst case scenario when a judge, a court would decide that they are not allowed to use their technology, so they have to find solutions to work around the patent. So a litigation already is very helpful right at the beginning, actually, because the competitors will need to react accordingly.
Now, there's obviously some adaptation to potential litigation needed. A firm that wonderfully prosecutes your patent but is not at all familiar with litigation is not what you need. And also, you and your processes and teams in-house must have some acquaintance with enforcing patents.
And you should have a budget as well. What I rarely see is that companies, even large companies, that they have a dedicated budget for litigation. They all have a dedicated budget for prosecution, for filing applications abroad, for paying the yearly fees, for inventor compensations. But they rarely have a dedicated budget for litigation purposes. And that's, I believe, what patent departments should do in mid-sized companies, but also in larger companies.
They consider litigation as being accidents, and you don't budget for accidents, right?
Yes, that's the case, yeah.
Yeah, now, of course, if you want to use your patents, you have to obtain them first, and you have to obtain them quickly enough. And you remember that client years ago, a Formula One team, who asked us, can't you protect with patents our newest developments for the next season. And of course, we cannot in real life, because the whole patenting process until the time until a patent has issued is way longer than the lifetime of those developments in Formula One. Now, even in normal technologies where time doesn't run so quickly as in Formula One, there's typically the question, do I get my patents in time? It's a race against time.
Absolutely. I mean, even if your examination proceedings is relatively quickly, you have to expect like 3 to 4 years before grant of a patent. There are certain ways to accelerate it, like the PACE program at the EPO. There's always also the possibility to file divisional applications in which you try to get a broader scope of protection, which might require more time, more communication with the examiner, and to be satisfied with a more limited scope of protection, which you might get quicker by the patent office.
Right.
And there's, of course, the possibility to file utility models in Germany.
Yeah. Every now and then, it's a good idea to branch off your utility model and to use that as a basis for litigation, way before a patent may be granted. Now, obtaining patents is the second step. The first step is collecting the inventions within your company. And that's what we'll deal with in the next part.